Ladies and gentlemen, welcome to today's webinar titled Federal No Surprise Act, the IDR process, good faith estimates, and what providers need to know, brought to you by Webinar Planet. This webinar will be presented by industry expert Thomas J. Force, and it will be recorded to purchase later in the form of DVD, transcript, flash drive, and digital download. If you wish to ask questions during the webinar, please type it in the question box and it will be later answered by the speaker during the Q&A session. Thomas, welcome to the program. We are now ready to begin.
Thank you so much. Thanks for everyone for attending. So let's make sure we understand the purpose of this presentation. This is not, although I'm an attorney, I did not prepare this presentation for audience of lawyers. This is more of a summary, a basic summary of the No Surprise Bill law, a basic summary of the interim rules that just came out in September, at the end of September. There's going to be there are a lot of unanswered questions. I would recommend strongly that at the end of this presentation, if I cannot answer any questions, to email me or to Webinar Planet, and within 24 hours, I will get you an answer that'll be provided by myself or one of my attorneys that work for my company. The reason why I'm very interested in this law is that in addition to being an attorney, I own a medical billing company that caters primarily to out-of-network providers. So, obviously this law and the interim rules have a significant effect on out-of-network providers and me personally and all of my clients. So I'm going to dig in to summarizing the rules. The interim final rule came out on September 30th. It came out from the Departments of Health and Human Services, Department of Labor, and Department of Treasury. They jointly released this interim federal rule regarding the No Surprises Act. So what is the federal rule? Before we even summarize the No Surprise Act, what does the federal rule attempt to accomplish? Well, it discusses determining how the qualified payment amount is calculated. You will see in our summary that the qualified payment amount is the amount that the mediator or the independent dispute resolution arbitrator, for lack of a better word, will consider to be the rate if there is the dispute between the out-of-network provider and the insurance company. So under the interim final rules, as you will see, the arbitrator is to consider the qualified payment amount to be presumed correct. And that rate is the median in-network rate, not good for out-of-network providers. We'll talk a lot about that, all right? So it talks about the qualified payment amount. It reduces the role of bonuses, risk-sharing penalties, and other incentive-based and retrospective payments or payment adjustments in the calculation of the QPA. Again, not good. It establishes a structure for the interaction of state and federal surprise bill requirements, where the state law preempts federal law when either a set payment amount or a dispute resolution process is in place for state-regulated plans and, when applicable, self-funded ERISA plans that opt into state law. Now, whether or not state laws will preempt federal law is still, in my opinion, a gray area. I read the regulation, and I know that I have a lot of clients in states like Texas and New York that use the Fair Health at 80th percentile rate that are under the impression that the state laws are going to apply and preempt the federal law, and the QPA amount, which is the median in-network rate, won't apply. I'm not sure that that's the case. And to be honest with you, I don't really know the answer to that. Okay? So I'm just going to throw that out there. But we're going to discuss that as well. Okay. So it also outlines a process by which a patient receives notice and potentially provides consent to receive out of network care and forego the protection of this act. It establishes criteria for facilities and physician providers to provide required disclosure to patients about balanced billing protections by both state and federal law. It broadens the complaint process for patients, physicians, and plans, particularly patients who receive or wrongfully receive balanced bills, and reaffirms several patient protections for emergency medical care, including the prudent layperson standard. Now, that's what the interim final rule is attempting to accomplish.